Good afternoon. So we are now back for Wayfarer's opposition. So Stephanie Jones and Jones Works, they wanted to amend their complaint. Long after all discovery has closed, they wanted to amend their complaint, and they wanted to bring two new claims against Melissa Nathan and then add Jamie Heath as a defendant with another new claim. So this is Wayfarer's opposition to that. Which we will see. Okay. All right. So, 8 months after the April 18th, 2025 deadline set by the Rule 16 scheduling order and 2 months after fact discovery closed, plaintiffs moved to add two new claims against Melissa Nathan and add Jamie Heath as a new defendant to a third new claim. Leave should be denied. Rule 16b4 provides that a schedule may be modified only for good cause and with the judge's consent. The language of Rule 16b4 makes clear that the court may modify a scheduling order only if there is a showing of good cause. The primary consideration in determining whether a good cause exists is whether the moving party can demonstrate diligence. And you notice they're actually citing Jones v. Abel. Plaintiffs failed to satisfy their burden to establish good cause and diligence. This court has previously recognized that waiting 6 weeks after discovering underlying facts before taking action demonstrates a lack of diligence. And again, they cite the judge's decision in this lawsuit. There can be no dispute that plaintiffs knew the facts underlying their proposed defamation and tortious interference with prospective business relations claims against Nathan from the inception of this action, because those allegations were included in their December 24th, 2024 complaint. Yeah, so in Jones Works' original complaint, she actually does make these allegations. She just does not bring the causes of action against Melissa Nathan at the time. So Wayfarer are absolutely right. There cannot actually be any dispute because they are all in her original complaint. Plaintiffs did not seek discovery into Nathan's alleged involvement with planting a negative article about Stephanie Jones and the publication of purportedly defamatory statements on certain websites until July 16th, 2025, after the statute of limitations for defamation expired and nearly a year after the publication of the article. Plaintiffs then waited months until after they admittedly learned of the facts they claim were necessary to bring this motion. Plaintiffs attempt to sidestep the Rule 16b diligence requirement by relying on the more lenient standard for leave to amend under Rule 15a, focusing on an alleged lack of prejudice to Nathan and Heath, and that amendment is not futile. But those considerations are only relevant if the plaintiffs first establish that they were diligent, which they have not done. Even under the more lenient Rule 15 standard, amendment should not be permitted. Nathan and non-party Heath would be prejudiced by the addition of these claims, which would require reopening discovery which is closed to redepose Jones and depose third parties. Additionally, the claims plaintiffs seek to add are legally insufficient, and thus amendment is futile. First, the 1-year statute of limitations for defamation has expired, and the proposed claim against Nathan does not relate back to the existing claims. Plaintiffs also failed to identify Nathan's allegedly defamatory statements and when the statements were made as required to plead defamation. Second, plaintiffs' newly contrived tortious interference with prospective business relations claim against Nathan is duplicative of the proposed defamation claim, and the allegations make it clear that any purported interference by Nathan was at least partially economically justified. Finally, plaintiffs' proposed claim against Heath for violation of Illinois Consolidated Statutes, the Illinois Eavesdropping Act, is deficient because 1. Plaintiffs have not met the $75,000 threshold for subject matter jurisdiction. 2. Plaintiffs failed to adequately allege the court's personal jurisdiction over Heath. 3. Illinois law does not apply. 4. Plaintiffs failed to plead a reasonable expectation of privacy. And 5. Plaintiffs failed to plead actual damages from the allegedly wrongful recording as required to plead a violation of the Illinois Eavesdropping Act. Hence, plaintiffs' motion for leave to amend should be denied. Okay, so background. On December 24th, 2024, the Jones parties filed a complaint against the Wayfarer parties. The complaint alleges 8 causes of action. 1. Count 1 for breach of contract of the employment agreement between Jones Works and Able. 2. Count 2 for tortious interference with the Able employment agreement against Nathan, Wayfarer and Baldoni. 3. Count 3 for breach of the contract of the engagement agreement between Jones Works and Wayfarer. 4. Count 4 for tortious interference with the Wayfarer agreement against Able and Nathan. 5. Count 5 for faithless servant against Able. 6. Count 6 for breach of fiduciary duty against Able. 7. Count 7 for defamation against Able. And 8. Count 8 for defamation against defendants John Doe through 1 through to 10. Among other things, the complaint alleges that Nathan contrived to plant a negative story about Jones in a Business Insider article called Who's Afraid of Stephanie Jones? And that Nathan and non-party Jed Wallace purportedly acted in concert with Doe's 1 through 10 to publish allegedly defamatory statements on websites about plaintiffs. On December 31st, 2024, Blake Lively filed a complaint against the Wayfarer parties, Heath, and others in the action entitled Lively against Wayfarer Studios, for allegedly orchestrating a digital smear campaign against her in retaliation for reporting supposed misconduct on the set of the film It Ends With Us. On February 3rd, 2025, the court in this action largely adopted the case management plan and scheduling order filed in the Lively action, including an April 18th, 2025 deadline for the amendment of pleadings. On July 16th, 2025, the Jones parties served Nathan with document requests for material relating to Nathan's redacted. As of the July 1st, 2025 deadline for substantial completion of discovery, the Jones parties had not moved to compel or otherwise claimed that Nathan's production was inadequate. Nathan produced additional documents on August 6, 2025, which she designated as attorney's eyes only, under the protective order in this action, because the new documents included information about her other clients. According to the Jones parties, the August production included documents purportedly showing Nathan redacted. On September 5th, 2025, the Jones parties deposed Catherine Case, a former employee of Jones Works and Nathan's PR agency, TAG. Nathan designated Case's testimony as attorney's eyes only, as the examination implicated work performed for other TAG accounts that do not concern this matter. The Jones parties claim that Case's testimony evidences Nathan's involvement with the website. The Jones parties subsequently moved to have this attorney's eyes only designation removed, and the court ordered the testimony de-designated over Nathan's opposition on September 19th, 2025. The Jones parties deposed Nathan on September 30th, 2025, and Wallace on October 10th, 2025. Each denied having any personal involvement in the websites. Okay. In a November 26, 2025 memorandum and order, this court denied the Jones party's motion to compel case to produce further materials relating to the websites in response to a subpoena dated October 17, 2025. The Jones parties argued that they sought materials in response to information obtained from the depositions of Case, Nathan, and Wallace. However, the court held that the Jones parties should have issued the subpoena as soon as possible after Case's September 5th, 2025 deposition, and the decision to wait an additional 6 weeks before doing so demonstrates a lack of diligence. In response to the Jones party's contention that there would be no prejudice because there was not yet a deadline for the summary judgment motions, the court noted that does not mean that the parties are free to continue to issue pre-trial fact subpoenas up to the moment of summary judgment. The absence of prejudice alone is insufficient to show presence of good cause. Nope. On October 5th, 2025, prior to his deposition in the Lively action, Heath produced a recording of an August 8th, 2024 phone call with Jones, who was in London. Okay, that's interesting. I didn't know she was in London, so that may change things. At the time the call was made, Jones Works was still representing Wayfarer in connection with the public relations crisis developing around the film and in connection with matters unrelated to the Lively fiasco. During his deposition, Heath explained that he recorded his call with Jones because of increasing concerns over Jones's conduct. On December 8th, 2025, the Jones parties moved for leave to amend their complaint to add claims for 1. Defamation against Nathan regarding redacted. 2. Tortious interference with prospective business relations against Nathan arising from redacted. And 3. Violation of the Illinois Eavesdropping Act against Heath for his recording of the phone call with Jones. Okay. Plaintiffs are not entitled to leave to amend. Plaintiffs have not shown the diligence required by Rule 16. Plaintiffs' motion for leave to amend the complaint should be denied due to their lack of diligence necessary to show good cause to amend pursuant to Rule 16 of the Federal Rules of Civil Procedure. Especially egregious is plaintiffs' attempts to add claims for defamation and tortious interference with prospective business relations against Nathan arising from redacted, because plaintiff's current complaint, filed on December 24, 2024, already contains allegations about Nathan's purported involvement therein. Thus, the Jones parties knew or should have known about the facts necessary to bring these claims not just months prior to the April 18, 2025 amendment deadline, but at the inception of this case. This alone is grounds to deny the motion to amend to add these claims. Rule 16 governs motions for leave to amend after a scheduling order has been entered, and thus Rule 16 governs plaintiff's motion. Rule 16b provides that a scheduling order must limit the time to amend the pleadings, and that a schedule may be modified only for good cause and with the judge's consent. The Second Circuit is clear that Rule 16 provides that when a deadline in the scheduling order cannot reasonably be met despite the diligence of the party, where the moving party has demonstrated good cause, the court may grant leave to amend the scheduling order to extend the deadline. Rule 16b is well established as a heightened standard because Rule 16 is designed to offer a measure of certainty in pre-trial proceedings, ensuring that at some point both the parties and the pleadings will be fixed. The Second Circuit is clear that Rule 16's standards may not be short-circuited by an appeal to those of Rule 15, as Rule 16 requires a different analysis, an analysis of good cause. If we considered only Rule 15a without regard to Rule 16b, we would render scheduling orders meaningless and effectively would read Rule 16b and its good cause requirement out of the Federal Rules of Civil Procedure. In similar context to the one here, courts hold that although Rule 15a generally is interpreted permissively, the plaintiffs do not enjoy such a liberal interpretation under Rule 16b. The primary consideration in the Rule 16 good cause inquiry is the movement's diligence. If the party was not diligent, the inquiry should end. Courts routinely deny leave to amend after a scheduling order deadline where the movement fails to show diligence in discovering the facts or in seeking amendment. The absence or presence of prejudice cannot be used to sidestep the Rule 16b diligence requirement. For motions to amend governed by Rule 16b, although the existence or degree of prejudice to the party opposing the modification might supply additional reasons to deny a motion, the focus of the inquiry is upon the moving party's reasons for seeking modification. In other words, a district court may consider the relevant factors aside from diligence, including whether the amendment of the pleading will prejudice the defendant, but the absence of prejudice to a non-moving party does not alone fulfill the good cause requirement of Rule 16b. The moving party must first show diligence. Despite clear guidance from the Second Circuit, plaintiffs incorrectly argue that the standard of Rule 15 applies for plaintiffs' untimely amendment. It does not. However, even if plaintiffs had timely filed their motion to amend the complaint 9 months ago and within the parameters of this court's scheduling order, which they did not, plaintiffs will fail to satisfy the more lenient Rule 15 standard. Under Rule 15, motions to amend should generally be denied in instances of futility, undue delay, bad faith, or dilatory motive, repeated failure to cure deficiencies by amendments previously allowed, or undue prejudice to the non-moving party. Moreover, according to the proposed amended complaint, Nathan's alleged involvement in the publication of false statements on the websites occurred in May 2024, and the Business Insider article was published on August 15, 2024. Yet the Jones parties did not serve discovery requests seeking redacted until July 16, 2025, after the statute of limitations had run on any defamation claim relating to the websites and nearly a year after the publication of the Business Insider article. The Jones parties' lengthy and unexplained delay in seeking discovery regarding these issues, which underlie their proposed claims against Nathan in the current motion for leave to amend the complaint, further demonstrates their lack of diligence. That's fair. Plaintiffs concede that they knew about Nathan's alleged involvement with the Business Insider article at least as early as August 6, 2025, when Nathan produced documents relating to this allegation. Yet plaintiffs did not move for leave to amend until December 8, 2025, over 4 months after they reportedly learned of this fact. As this court held in the case motion to compel order, a 6-week delay demonstrates a lack of diligence. Here, plaintiff's delay lasted over twice as long and is therefore even stronger evidence of their lack of diligence. Similarly, plaintiffs concede that they knew about the recording of the phone call that forms the basis for their proposed Illinois Eavesdropping Act claim against Heath as of October 5th, 2025. Yet they waited over 2 months to bring this motion. Again, longer than the 6 weeks this court held evidenced a lack of diligence. Plaintiffs' long-standing pattern of lack of diligence eviscerates any argument they have to show good cause pursuant to Federal Rules of Civil Procedure 16, and thus their motion for leave to amend should be denied, and the court should end its inquiry there. And then there's a footnote which I will read. On related note, the initial case management plan and scheduling order was filed by the court on February 3rd, 2025. Lively, Jones and Jones Works moved to amend the scheduling order to extend various discovery dates and the date for motions to compel. Jones Works did not seek to amend the deadline for amending the complaint. On July 15th, 2025, the court amended the scheduling order, but it did not amend the deadline for parties to seek leave to amend their complaints. On October 6th, 2025, the scheduling order was amended with respect to expert disclosures and discovery. Again, no amendment was requested or ordered with respect to the deadline for amending the pleadings. Okay. So far, so good. Plaintiffs are not entitled to leave to amend under Rule 15. Nathan and Heath would be prejudiced by the late amendments. Although Rule 15 provides that leave should be freely given when justice so requires, amendment should be denied for undue delay, bad faith, or dilatory motive on the part of the movement, repeated failure to cure deficiencies by amendments previously allowed, undue prejudice to the opposing party, or futility of the amendment. Undue delay, bad faith, and dilatory motive weigh against amendment. The failure to show diligence under Rule 16 should weigh heavily against, if not forecloses, amendment under the more liberal requirements set forth Rule 15A2. While a lack of diligence and undue delay are factors, prejudice is considered the most important factor in a Rule 15 determination. Prejudice exists where amendment would require significant additional discovery, cause substantial delay, or alter the litigation's nature on the eve of dispositive motions or trial. Plaintiffs' amendments would require significant additional discovery, further delay in resolution of this action. For instance, plaintiffs initially asserted a defamation claim against John Doe's. A defamation claim against Nathan would require new discovery on, among other things, whether any of the alleged defamatory statements were true or otherwise privileged to whom the statements were made, when the statements were made, and plaintiffs' purported damages flowing from each allegedly defamatory statement. At the very least, A. Jones and Jones Works depositions would have to be reopened. B. Additional written discovery would have to be propounded upon the parties. C. Subpoenas would have to be served upon non-parties, including current and former employees of Jones Works, as well as current and former clients of Jones Works, and D. Those non-parties would have to be deposed. And I'm guessing there would be expert discovery as well. Yeah, I think Mia just agreed with me. The proposed tortious interference with prospective business relations claim against Nathan would also require substantial discovery to determine the non-speculative business opportunities that would have been available to plaintiffs and the concrete profits that those claimed future opportunities would have generated. While discovery was conducted on plaintiffs' existing claim for interference with existing contracts, discovery on potential future relationships would open a whole new ballpark of fact discovery on subjects which are irrelevant to the existing claims and thus has not been delved into by any party. For instance, With respect to the Business Insider article, A. Jones and Jones works would have to be redeposed. B. Subpoenas for documents would have to be issued to Business Insider, as well as to all sources of information used in the article. All right. And C. The authors and anyone who provided information for the article would need to be deposed. Expert discovery would also be implicated on the reasonableness of claimed losses from future business relationships. Finally, Heath is a new party to this lawsuit. Heath would be entitled to discovery relevant to the new eavesdropping claim and his defences. For instance, under Illinois law, plaintiffs must prove actual damages from the alleged recording. Thus, crucial discovery, including plaintiffs' depositions, would be required to establish whether plaintiffs were damaged by a single recorded call between Heath and Wayfarer's public relations agent, Jones, and the amount of such damages claimed, if any. Heath may also seek non-party discovery from Jones's family members who were in London with Jones and may have been present during the call, destroying any reasonable expectation of privacy, an essential element of an Illinois eavesdropping claim. In sum, the extensive additional discovery that would be required by the amendments long after the close of discovery would significantly and unduly prejudice defendants and delay trial. Okay. The proposed amendments are futile. In assessing futility of amendment, courts apply the same standard as Rule 12b-6, motion to dismiss. Thus, an amendment is futile if it would not survive a motion to dismiss. Where claims are time-barred or legally deficient as a matter of law, amendment is futile. The proposed defamation claim is time-barred. New York law provides a 1-year statute of limitations for defamation claims. Thus, if the proposed claim for defamation against Nathan does not relate back to the complaint, the claim is untimely. CPLR Section 1024 allows for a DOE substitution on a related party theory after expiration of the statute of limitation party, where a plaintiff, 1, exercised due diligence prior to the running of the statute of limitations to identify the defendant by name, and 2, describe the DOE party in such form as will fairly apprise the party that he is the intended defendant. John Doe pleadings cannot be used to circumvent statutes of limitations. Plaintiffs failed to make a diligent effort to identify Nathan as the unknown defendant prior to the commencement of this action through the date of the statute of limitations expired. There is no evidence the plaintiffs exercised any pre-action due diligence to ascertain the identities of the John Doe defendants. The alleged defamatory websites were published in May 2024. Plaintiffs waited more than 7 months until December 24, 2024 to commence this action. Plaintiffs then waited another 7 months until July 16, 2025 to serve Nathan with requests for documents pertaining to the redacted. Those requests were served after the statute of limitations expired in May 2025. There's a footnote. Although plaintiffs allege they also served subpoenas on the platforms hosting the websites and social media pages, they neglected to attach those subpoenas to their motion, likely because they too were not served in a diligent fashion. Okay. According to their complaint filed a year ago, plaintiffs believe the John Doe defendants acted in concert with Nathan to publish the websites. In other words, plaintiffs knew of Nathan's identity and purported involvement with the websites when they filed their complaint in December 2024, but nevertheless waited until after the statute of limitations expired to assert a defamation claim against her. Plaintiffs have not exercised the due diligence necessary to invoke the relation back doctrine. An amendment to add a defamation claim is futile. So plaintiffs fail to plead the elements of defamation. To plead defamation, a plaintiff must adequately allege 1. A written defamatory statement of fact concerning the plaintiff. 2. Publication to a third party. 3. Fault, either negligence or actual malice. 4. Falsity of the defamatory statement. And 5. Special damages or per se actionability. The complaint must identify the purported communication and an indication of who made the statement, when it was made, and to whom it was communicated. First, plaintiffs do not attribute a particular statement to Nathan. Rather, Nathan allegedly made or published defamatory statements to at least one other person, and in some cases to multiple persons. Wallace and Nathan published the false and defamatory website about Jones and Jones Works. Such group pleading is insufficient to meet the exacting standard for identifying the maker of each communication. In addition, with a single exception, plaintiffs have failed to identify what the temporal aspect of the statements with the requisite specificity. The proposed amended complaint identifies only one date when a single alleged defamatory statement was made, but no others. Thus, the temporal aspect of the defamation claim is insufficiently pled and the claim is deficient. The proposed tortious interference claim is deficient. The tortious interference claim is duplicative. In Goldman, the Second Circuit held that a tortious interference claim must be dismissed as duplicative where it is premised on identical underlying factual content as a defamation claim. Where the alleged harm derives from purported defamatory statements rather than an independent source, the tortious interference claim cannot survive as a separate cause of action because claims surrounding in tort are in fact defamation claims, where the entire injury complained of by plaintiff flows from the effect on his reputation. Plaintiff's proposed claim for tortious interference with prospective business relations is duplicative of the defamation claim. Both claims arise from Nathan's purported publishing of false statements on the websites. Most importantly, the alleged harm to the plaintiffs from both claims arises out of the purported effect on plaintiff's reputation. Because the tortious interference claim against Nathan is duplicative of the defamation claim, amendment to add the tortious interference claim is futile and leave to amend should be denied. Okay. The tortious interference claim is not pled with specificity. To state a claim for tortious interference with business relations under New York law, a plaintiff must adequately allege that 1. The plaintiff had business relations with a third party. 2. The defendant interfered with those business relations. 3. The defendant acted for a wrongful purpose or used dishonest, unfair, or improper means. And 4. The defendant's acts injured the relationship. First, at the motion to dismiss stage, a plaintiff must specify some particular existing business relationship through which the plaintiff would have done business, but for the alleged tortious behavior. Plaintiffs failed to specify any business relationships with which Nathan purportedly interfered, referring only to a single unidentified mutual client, which is insufficient to plead a tortious interference claim. Next, for wrongful means, a plaintiff must demonstrate that the defendant's conduct amounted to a crime or an independent tort. Plaintiffs' allegations are woefully short of meeting this standard. Plaintiffs allege that Nathan engaged in a public relations campaign to plant negative and false stories in the press and on the internet about plaintiffs. This conduct does not amount to a crime or independent tort. Pleading the presence of false statements alone is not enough to support a claim for tortious interference. Finally, conduct constituting tortious interference with business relations is, by definition, conduct directed not at the plaintiff itself, but at the party with which the plaintiff has or seeks to have a relationship. Thus, allegations that are directed at the plaintiff rather than a third party could not satisfy the wrongful means element, even if they did sufficiently allege tortious conduct. Here, plaintiffs' allegations of misconduct are entirely directed at plaintiffs themselves. Nathan is alleged to have carried out a negative publicity campaign directed at plaintiffs. There are no allegations of any conduct by Nathan toward any third parties, including the unidentified mutual client. Therefore, plaintiffs have failed to adequately plead a claim for tortious interference with prospective business relations. This claim is insufficient, and the request to add it should be denied. The alleged tortious interference is economically justified. A well-recognized defense to a claim for tortious interference with prospective business relations is that the conduct at issue was taken to protect a party's economic interest. When a defendant has acted with a permissible purpose, such as normal economic self-interest, wrongful means have not been shown, even if the defendant was indifferent to the plaintiff's fate. In RBG Management Court, for instance, the court dismissed tortious interference with prospective business relation claims where the defendant's actions were motivated by legitimate competitive interest rather than a wrongful purpose. Plaintiff's proposed tortious interference claims fails because it alleges that the conduct at issue was undertaken by Nathan at least partly for a legitimate competitive purpose rather than a wrongful one. Plaintiffs allege that Nathan's negative public relations campaign was done intending for a mutual client to terminate his relationship with Jones and Jones Works, and that the mutual client ultimately and as a result did not renew or enter into an agreement with Jones and Jones Works that he would have but for the aforementioned conduct. Indeed, plaintiffs expressly allege that Nathan's motivation was for Nathan to maintain that client. By plaintiff's own allegations, therefore, the alleged conduct was undertaken for a competitive purpose and to protect Nathan's relationship with this purported mutual client. For this additional reason, the claim for tortious interference with prospective business relations is insufficient, and the motion to amend to add this claim should be denied. Okay, so now we're getting into the one I really want to hear about, which is the Illinois Eavesdropping Act claim that she wants to bring against Jamie Heath. The proposed eavesdropping claim is deficient. Plaintiffs fails to plead subject matter jurisdiction. Subject matter jurisdiction requires plaintiffs must plead damages that exceed $75,000, exclusive of interest and costs. This amount in controversy threshold cannot be aggregated among various defendants. It must be satisfied with respect to each defendant. Okay. Plaintiff's proposed claim for violation of the Illinois Eavesdropping Act fails to establish to a reasonable probability that Heath's recording of a single phone call would or did cause plaintiffs in excess of $75,000 in damages. In fact, plaintiffs do not claim any damages specifically in connection with this proposed cause of action. Rather, plaintiffs merely allege in conclusory fashion that all their claims in the aggregate exceed $75,000. That is insufficient because the law is clear that plaintiff must satisfy the jurisdictional amount as against each individual defendant. Moreover, plaintiffs do not allege facts sufficient to make damages exceeding $75,000 reasonably probable, as is required. Plaintiffs do not allege, for instance, that Heath published, disseminated, or otherwise used the recording in any improper way that would have caused them damage. Accordingly, plaintiffs failed to plead to a legal certainty that this claim would support damages in excess of $75,000. Plaintiffs do not plead personal jurisdiction over Heath. Plaintiff's proposed amended complaint fails to allege personal jurisdiction over Heath either under New York's long-arm statute or the Due Process Clause. The plaintiff bears the burden of establishing that the court has jurisdiction over the defendant. The proposed amended complaint does not allege that Heath is domiciled, physically present, or personally does business in New York as required to support an exercise of general jurisdiction under CPLR Section 301. Plaintiff's Illinois Eavesdropping Act claim does not arise out of activities that Heath purposely directed at New York. The alleged conduct on which plaintiff's claims is based did not take place in New York. Heath placed a call from Illinois to Jones in London. While Jones Works has its principal place of business in New York, personal jurisdiction turns on a defendant's contacts with the forum state, not a defendant's contacts with a plaintiff who resides in the forum. The proper question is not where the plaintiff experienced a particular injury or effect, but whether the defendant's conduct connects him to the forum in a meaningful way. Plaintiffs do not adequately allege that either prong of CPLR Section 302A3 is satisfied to support an exercise of specific jurisdiction. Plaintiffs argue that Heath is already a named defendant in the Lively matter, but it is well established that participating in other litigation cannot establish specific jurisdiction, which must be based on contacts with the forum related to the claim at issue. Involvement in other cases in New York does not create specific jurisdiction because a defendant's relationship with a third party standing alone is an insufficient basis for jurisdiction, and those other cases create no connection between the forum and the specific claims at issue here. Thus, the claim cannot proceed. The Illinois Eavesdropping Act does not apply. Even if this court had jurisdiction over the claim against Heath, the Illinois Eavesdropping Act does not apply. The only hook for plaintiff's proposed claim under the Illinois Eavesdropping Act was Heath's temporary presence in Illinois when the call in question was made. However, neither plaintiffs nor Heath are domiciled in Illinois, and neither are alleged to have any interest in or connection with Illinois. Because there is no basis to apply the Illinois Eavesdropping Act here, adding the proposed claim is futile. Plaintiffs lack standing to bring a statutory claim under Illinois law. Indeed, courts routinely hold that a plaintiff is unable to pursue claims based on statutory causes of action created by states where plaintiffs neither lived nor were injured. Given that the purpose of the Illinois law is to assure Illinois citizens that their conversations would not be recorded by another person without their consent, there is no basis to apply the law to a claim brought by plaintiffs who are not alleged to have suffered any injury in Illinois. Given that the court lacks subject matter jurisdiction over the proposed claim against Heath and lacks personal jurisdiction over him, and given that the Illinois Eavesdropping Act is inapplicable, the court need not decide whether the laws of the United Kingdom, where Jones was located at the time of the call, New York, where Jones Works maintains its principal place of business, or some other jurisdiction applies to any claim by plaintiffs for eavesdropping, and whether under that law plaintiffs can state a claim. For example, New York law permits conversations to be recorded with the consent of only one party. I'm speaking for the UK. It's not illegal to record calls at all, especially in this context. So people can record each other, right? And we don't get a bug up our ass about it. Should you let someone know that you were recording and seek their consent? Yeah, you should. That's good practice and considered the polite way of doing it, but you do not have to. And especially because it all comes down to what are you going to be discussing, right? And if I wanted to call my doctor, for instance, right, and I wanted to record the call, so I've got a record. So if something different turns up in my medical file to what I've been told on the phone, I can hold them to account for it and say, no, you said this. And when they say, no, I didn't, I can pull out a recording and say, hey, yes, you did. Listen to yourself. There are a variety of reasons that recording calls are actually, useful. In that situation specifically where I'm the patient speaking to my doctor, or in this situation where Heath is the client of Jones Works and he is speaking to the Jones Works CEO, Stephanie Jones, you are likely to be discussing your own data. So Heath would be talking about Wayfarer and it would be their data. I would be talking about something on my medical records, my health, whatever, and it would be my data. We would not be discussing data of my doctor or of, and Heath was probably not going to be discussing the data, the personal secrets and all that of Jones Works, which, she could have then argued and said, well, hold on, I'm entitled to privacy. In that, in the context of business calls, normally the client who has the stronger presumption of a right to privacy, because you are almost always going to be talking about information that affects the client. So, the only thing with the UK with these things is it's hit and miss whether courts will accept covert recordings as evidence. Some cases, some courts, some judges will accept it, others won't. I personally think it's something that should be accepted, because if someone is admitted to committing a crime or is caught, on a recording that they're not aware of, screaming at their wife, threatening to kill her or something, then I don't see why, on technical reasons, that should not be admitted as evidence in court. And people are more likely to say something they shouldn't when they don't know that it's being recorded. I find them personally useful, but I do understand as well why people don't want to be recorded. But in this case, I mean, Heath gave his reasons why he did it. He was concerned about her conduct. So we haven't heard the recording. And again, they were quite happy to use covert recording when it was Steve Sauerets. They were quite happy to have that entered into evidence. Not necessarily Jones or Jones Works, fine, but I'm sure she was fully supportive of Lively doing it. But when Claire Ayub was recording Steve Sauerets, no one raised any issues with, how awful that was. But that was also in Illinois. He was in Illinois. I can't remember where she was, but it's probably not important either. And, Steve Sauerets didn't rush off to make a claim against Claire Ayub or Lively for disseminating it, by the way. So, yeah, that's my view on that. Okay, plaintiffs do not establish a reasonable expectation of privacy. Assuming the Illinois Eavesdropping Act applies, the statute only applies where there is an expectation of privacy. 720 defines 720D, sorry, defines a conversation under the statute as any oral communication between two or more persons, whether in person or transmitted between the parties by wire or other means, when one or more of the parties intended the communication to be of a private nature under circumstances reasonably justifying that expectation. Where there is no expectation of privacy, a claim under the Illinois Eavesdropping Act fails. And this is what I mean, right? If it had been the other way around and Jones Works was recording Wayfarer as a client, then I would say there may have been, like it's their data. They would have been talking about their account, their business. So I would have said, well, there's more likely to be a reasonable expectation of privacy in that scenario. Where there's Stephanie Jones, who is the CEO of the PR company, and she's on a call with her client, I see a much weaker claim to her expectation of her privacy, because they would not have been talking about, how Jones Works runs its day-to-day business, any, confidential business information that belonged to Jones Works. And, just to bring out the hypocrisy card here a little bit, I'm sure Stephanie Jones did not feel this way when she rushed off to comply with an immoral subpoena, a sham subpoena. When she rushed off to hand over all of Jen Abel's phone data, and it wasn't just the phone data, right? People think it was just the phone data. It was not. There was other things as well, as stuff that specifically related to Baldoni, to Wayfarer, as well as, so it would have been like, documents, emails, business agreements. She keeps saying, I complied with a lawful subpoena. I am really struggling with any acceptance that subpoena was lawful. But even if it was, I find it incredibly unethical and immoral. And I don't see Stephanie Jones showing the slightest bit of concern for anyone's reasonable expectation of privacy. She did not notify Wayfarer at all. She did not notify Jen Abel at all that she had even been served with a subpoena. And that was all done deliberately, to be very clear. I mean, even the minute Jen Abel walked out the office, she was already sharing messages that were on her phone with other colleagues, because they contacted Jen Abel and said that they'd seen her messages. Leslie Sloan contacted Melissa Nathan and said, I've seen your messages. So, to sit here and watch Stephanie Jones go through all of this and basically implode because, God forbid she's had a phone call recorded without her knowledge, which was probably a big nothing burger anyway. But, let's throw in a claim, and now I get to amend everything and redo discovery again, which is what she's actually wanting for us, the end game. It's absolutely wild when she has, I can't even point to a moment where in this lawsuit and before it, in the whole lead up to it, where she had any concern for anyone else's privacy. Not even Blake Lively's, So, this woman is just nuts. She really is, like. Okay. Plaintiffs do not plead a reasonable expectation of privacy because, 1, at the time of the call, Jones was with other individuals who could overhear her. Exactly. So if it's a confidential business call, don't be surrounding yourself with people. And 2, both parties contemplated sharing and in fact did share the content of the call with others. Well, that's a fucking surprise. Of course they did. Thus, the Illinois Eavesdropping Act claim is legally insufficient, and the motion to amend to add this claim should be denied. This claim is also complete and utter bullshit. As Jones noted in contemporaneous communications, she was in London with her family at the time the call was made. On the call itself, Jones stated, "My entire family is here." Because she was. It says there she was in the deposition. Jones can be heard speaking with someone else. And there are other voices on Jones's side of the call. Accordingly, Jones did not have a reasonable expectation of privacy on the call. The proposed Illinois Eavesdropping Act claim fails. Further, the purpose of the call between Jones and Heath was to discuss Jones' work's role as representative of the Wayfarer parties under the Wayfarer agreement. Sorry, I've been talking for a long time now. My mouth just goes numb. Right. Jones's role as a representative of the Wayfarer parties under the Wayfarer agreement, whether plaintiffs were responsible for a leak to the Daily Mail, and whether or not plaintiffs should continue to speak publicly on behalf of the Wayfarer parties. At various times on the call, Jones indicated her intention to communicate the content of the call with third parties. I mean, she also said all this in text messages too, which I will be doing next in my next video. There's some text messages. True to her word, Jones did in fact discuss the content of the call extensively with other parties besides Heath. The same day as the call, for example, she engaged in an extensive texting thread with not only Heath but also Abel and Tara Hanks. Yes, those are the texts I have. Tara Hanks, the latter a representative of the Wayfarer parties, that covered who was responsible for the Daily Mail leak, as well as whether plaintiffs could respond to media inquiries on behalf of the Wayfarer parties. The next day, August 9th, 2024, Jones redacted. And on August 14th, 2024, as she had threatened to do, Jones redacted. Because Jones shared the content of the call with others besides Heath, she can have had no reasonable expectation of privacy regarding the call. Thus, the proposed Illinois Eavesdropping Act is deficient and the motion to amend to add it should be denied. I agree with all of that. Plaintiffs failed to plead any actual damages. Civil remedies for violation of the Illinois Eavesdropping Act are 1. Injunctive relief, 2. Actual damages, and 3. Punitive damages. As noted, plaintiffs failed to plead actual damages, rendering the claim legally insufficient. Notably, even if plaintiffs sought punitive damages, such damages are warranted only in cases when an individual acts with malice, deliberate violence, or gross negligence, indicating a wanton disregard for the rights of others, none of which is pleaded or evident from the allegations of this claim. Conclusion. For all the foregoing reasons, plaintiff's motion should be denied in its entirety. Again, that's like the second fantastic filing from Mr. Fritz today. I love reading his stuff. I do. He is so articulate in putting across his arguments and counter arguments. Amazing job. Okay, so Stephanie Jones will file a short reply, and we'll get to hear about that in about a week's time. Okay, so I'm going to do the text message thread that was just mentioned then with Stephanie Jones, Jamie Heath, Jen Abel, and I think Tara Hanks. And then I've got Popcorn Planet. They have filed the grounds for appeal. And I've got to say, I do love that filing. I think it's a great filing. So I'm excited to read that. Okay, thank you very much, guys.